legal, okay, legal deadlines and the legal deadlines under law, time to file lawsuits, times to respond, time to appeal and whatnot, has no effect on contractual agreements whatsoever. Next slide, which sort of leads us to, the general principle is the contract that you have for sale of property or any other contract is the law between the parties. So unless there is something from a public policy standpoint that the governor, legislature are trying to overcome, nothing as far as getting passed in a new law or executive order and all is generally going to change anything in the agreement.
Yeah, and the one sort of extraordinary circumstance recently was the eviction moratorium. So there was a moratorium passed by the federal government saying, hey, you can't evict anyone because of this public health emergency. So that's an instance where a public health emergency sort of superseded the lease agreement that you might have with your tenant. But again, it takes extraordinary sort of circumstances to do that. And in this case, we haven't had any generally applicable sort of orders or anything that would change how contracts are enforced or interpreted.
So that's why, it's advisable to always have a very clear and concise agreement, a buy and sell agreement. I told a story at another conference like this that I always argue with my realtor that because I'm a lawyer and I'm anal retentive, that I want to have every detail in an agreement that I'm going to be a party to. And she always argues that, well, of course they know that. Of course they know that. But I'm going to put it down anyway. So those blank lines in those forms are there for a reason. If you can, the more precise you can be, the better. And it's a very important. Next slide, which leads to the next principle, and that is that once you have a written contract and an agreement to buy and sell real estate, it has to be in writing, obviously, that it can only be modified by another written agreement consented to by the parties. Can't have a verbal agreement that we're going to push the closing back. Okay, see you then. It needs to be in written form. Verbal agreements cannot modify written contracts, only in very rare circumstances. And in fact, the courts won't even consider those verbal agreements. Next slide. So the next question that often came up was, does the hurricane itself, the event of the hurricane, change in some way, excuse the timely performance under a contract, particularly the residential agreement to buy sell? Next slide. Force majeure, for those who may not be familiar, is a contractual clause. It's not a concept that's imposed by law. It's a contractual clause, and it excuses someone from performing under a contract because of an extraordinary event, a natural disaster, act of God. These were pretty boilerplate in a lot of agreements, and after certain events, they sort of get more detailed. When COVID first arose in 2020, there were a lot of questions about whether COVID was an act of God or some other event that may have excused performance. Some contracts actually had pandemic as an event. Some had other epidemic or other orders of the government, shutdown and things like that. But for the most part, it doesn't really affect us here because the residential agreement form that is used in buy-sell agreements here doesn't have a force majeure clause. So because it's not written to the contract, it doesn't have any play here. But as I'll explain in a minute, that may not be the be-all end-all anyway. So next slide. Louisiana law does impose on contracts, though, the concept of a fortuitous event. So there's some event that is unforeseen and basically makes the performance impossible, which is a very key word, then that concept may intervene and excuse a delay in performance of the contract. Next slide. But from the court's interpretations, whether it's force majeure or whether it's a fortuitous event you're trying to rely on, there are a lot of cases that say the event has to be sort of unforeseeable. There has to be a connection between what was required in the contract and what the event prevented them from doing. And the performance can't be just difficult or inconvenient. It's got to be nearly impossible. Okay. And there's obviously very simple examples and very extreme examples under that. And the extreme example I use is back, in Katrina times, if you had a residential sale agreement for a home in say Chalmette, St. Bernard Parish, which had heavy flooding, and the house was located at 1500 Main Street before the hurricane, and after the hurricane, it was located at 1700 Main Street. Obviously, you can't perform under the agreement. The seller can't perform under the agreement. Those are the kinds of events that, whether it's force majeure or fortuitous event, would sort of intervene and excuse a party from performing. What that means is a court's not going to hold them to it. That's it. So there always would be a court or someone sort of interpreting that.
Yeah. And similarly, the buyer would have the right, if they were the one that wanted to back out, to say that, the performance of the contract can't be done by the seller, and therefore I shouldn't be required to continue because I contracted to buy 1500 Main Street and it's no longer there. So it works both ways. It's not, just seller, just buyer favorable. Either side can sort of exercise that fortuitous event or force majeure provision if it's in the contract.
Right. Next slide. So the bottom line is the fact that Hurricane Ida did impact our area is not necessarily alone a reason for a delay in contractual performance. There has to be some other correlation, has to be a nearly impossible, it must be impossible to perform because of the event before there's sort of any relief there. At this point, I'm going to turn it over to Eric to talk a little bit about evictions, proclamations, and legal court suspensions.
Yeah, so these issues came up, I think, after Hurricane Laura and again after Hurricane Ida, and several people sent in questions through their local associations or through the state association to get answers on some of these issues. And one of the big ones was about the governor's orders, and also the Supreme Court issues sort of corresponding orders usually in connection with whatever the governor issues with respect to suspension of timelines, suspension of legal rights, and things like eviction. So the question became, after the governor issued the order, what effect does that have on time delays that would have expired or would expire during the suspended period? So you can advance to the next one. And you can go ahead too, Amy. Initially, so a lot of this came up in connection with COVID, and it was because the governor issued a longstanding order that lasted several months about prescription and prescriptive periods and timelines in connection with the enforcement of legal rights, and basically cut those things off. And there was a question about whether or not the time period was simply suspended, meaning it stops running but starts again immediately once the order ends, or whether or not when the order ends, do you pick up that period of time where it was suspended? So if you had 90 days to file something and the order came down 30 days into that period, does your extra 60 days start once the order ends, or do you lose that 60 days, assuming that the order ended on day 90 and then you have 1 day? So the civil code sort of has a concept in there that, and you can advance to the next slide. The civil code has a provision in there that takes into account the idea that the clock stops, so to speak, and that suspension stops everything, and that the clock starts to run again when the suspension is lifted. So a lot of the courts during COVID were looking at that civil code article and saying, well, the governor's order says the periods are suspended, therefore this is what suspension means. However, you can go to the next slide. The legislature sort of overrode a lot of the court's interpretations on that and basically said that the period of time is suspended, but when that suspension stops, if your time period had ended during the suspension, you got 1 day after to go ahead and file your response in the lawsuit, or whatever your legal right might be. So for a lot of people, this was, if you wanted to file a lawsuit, you had to do it on that day if your period to file it hadn't run, or if you had to file an answer to a lawsuit. So that was, I think, surprising to some folks. It put a lot of people in a rush to hurry up and get responses. And it was interpreted differently by some courts, but that was what the legislator, that's how they addressed it.
And this is mostly, again, applicable to eviction proceedings here. And we would note that Act 162 was specific to the governor's suspended time delays related to COVID. It didn't say all gubernatorial proclamations are going to have this interpretation. So there's really a technical question about whether it applies to an emergency proclamation like Hurricane Laura, Hurricane Ida, and everything else. But some courts may pick that up and not really understand the difference. But technically, it only applied to the COVID proclamation that he passed.
Right. And so in this case, the courts could go back to the civil code article and say suspension means suspension as set forth in the civil code. Therefore, your period of time stop and it will start again, and you'll get the benefit of that full period of time once the suspension is over. So we'll see how courts move, but there is some discrepancy there in how that might be interpreted. So this all applies, due to the governor's order that again expired on the 24th, but also a Supreme Court order that had similar effect. So while the governor's order prescribed, the Supreme Court has extended their order, but only, and you can go to the next slide, Amy, only with respect to certain parishes. So you can see that there is a suspension of time periods, limitations, and delays pertaining to the initiation, continuation, appeal, etc., of any state or municipal matter within those parishes: Lafourche, Orleans, St. Charles, St. Helena, St. John the Baptist, and Terrebonne, for an additional 30 days. So that extended the period that would have otherwise ended on the 24th until September 26th.
That would end on the 26th.
Yeah, on the 27th, excuse me. So it goes until the 26th. Of October, yes. So that only applies to those periods. And again, that only applies to the right to enforce remedies sort of in the court or in administrative proceedings. This has nothing to do with your due diligence period under your contract or the financing contingency period or the objection period in your contract. This has everything to do with legal periods, like if you were going to try to evict a tenant, how would you go about doing that? Basically, in this case, if you were trying to evict a tenant in one of these parishes, you can initiate the eviction proceedings, right? Nothing prohibits you from starting that process. But the answer is that the tenant doesn't have to answer that suit and you can't get a judgment against the tenant for eviction until that suspension period has ended. And then, of course, the question becomes, okay, so let's say I started eviction proceedings today, and then we have a 30-day suspension of time. When that 30 days ends, does that mean the defendant has to answer tomorrow, or do they have the normal delay period after to file their answer? And I think that's still to be determined depending on what court you're in and what judge you have, probably. But that's the basics of it. So on next slide, you'll see, and the next few slides sort of go through the various courts in each of these parishes. So in Lafourche Parish, the 17th Judicial District Court, Terrebonne Parish, Clerk of Court's office closed. And that's another issue is, Clerk of Court's offices and recordings and filings. So when we're talking about closing transactions, obviously, if the clerk of court is not able to record a cash sale or record a mortgage, there's an issue with that. So title companies right now are issuing underwriting bulletins that address these issues. And the way they typically address them is how they've done it in other instances is there's an exception to the policy that can be added that allows for the closing to occur, but essentially says, look, if something happens between now and the time period between the clerk of court is able to get back up and function fully, and there was a problem when you went to search title because the indexing was off during that period of time, they're going to take an exception, the title insurer, for that any intervening matter, so to speak. So you can still do closings if the title insurance company is able to say, hey, we'll let you have that exception in the policy. But there might be some lenders who say, I'm not willing to issue the loan and accept a policy with that exception. And I think lenders might vary on that front. I don't know where most of them stand, but you get a policy that ensures good title and all that. It's just a question of whether or not there's some intervening matters that might pop up. And of course, the policy won't apply if that happens because there's an exception. Next slide is, again, talking about suspension of legal deadlines. It applies to the time period to initiate, continue, appeal, does not prohibit the posting of eviction notice or commencement of the proceeding, as we talked about before. Again, assuming that all the offices are open where you can go and actually file the lawsuit. So if you go to the clerk of court's office and say that you want to initiate a suit and there's nobody there in the civil processing department to do that, then you got a problem. But assuming the clerk of court's office is able to do that, you can get the suit started. It's just a matter of time about when they can respond or should be required to respond. Another issue that came up is security deposits and whether or not any of this, suspension of legal deadlines impacted the security deposits. And really, the answer is no. You have a 30-day period to return that's set forth by statute. It is not, there's no proceeding to enforce return of deposit necessarily. So the applicable deadline to return it still applies. Of course, the question comes up, well, if you have a security deposit, tenant's gone, place is damaged, probably due to a hurricane, do you have to return it within that 30-day period? What if you can't find the tenant and can't locate them? What do you do? So there's a process, where you can go to the treasurer of the state and deposit lost property if you can't locate the tenant because they've abandoned the premises due to the hurricane. Obviously, it's difficult from a landlord's perspective to know for sure, the state or condition of the property, whether or not, there was some damage prior to the hurricane. But if the hurricane's wiped it out completely, it's going to be difficult for you to say you can keep the deposit because it will be difficult to show that there was any damage done by the tenant.
And it's going to be hard to give a definitive answer on those to any particular situation because they're so fact-based.
Yeah.
And all you got to know is there is a process to determine that, and some of the factors, there are factors out there that are considered, but there's no way to plug it into a formula and know you've got the right answer every time.
All right. So next slide, we deal with the standard form purchase agreement. And the question that had come up is, does the agreement address what happens in the event of a hurricane or other natural disaster? And the short answer is really not. It doesn't address what we would consider sort of a casualty provision, say what happens in the event of a casualty, whether that's a fire, tornado, hurricane, or something else that destroys the property at issue or damages it to an extent that is no longer inhabitable or usable for its intended purpose. And the standard form purchase agreement doesn't have that provision in it. I know from talking to Kim that at one time that was considered, and I think it was decided that it was not at that time appropriate to put in. I think that may be revisited. I don't know the details of that, but at this point, there is no casualty provision. So when you start looking at the contract to see what other provisions might apply, you can see this first one, which says that the sale price of the property was negotiated based upon the property's current condition. So if at the time of entering into the contract, the property was in good shape, perfectly fine, we're going to pay $300,000 for this property, and then 2 weeks later, the hurricane hits, then you've got an argument to say, look, I'm not paying $300,000 for a house that just got hit by a hurricane and now all the windows are blown out, the roof is blown off, and it's not in the same condition. So as Troy said, in other instances, this usually is an obligation to make to limit the seller's obligation to make repairs. But in this case, you could say that, hey, the property is not what it was supposed to be. I wouldn't have paid this much for it, and therefore I don't have to buy it for the price we agreed upon. And then further down in the agreement on the next slide, you'll see probably a more applicable provision. And you can advance the slide, Amy. But at the same time, not necessarily directed at this particular circumstance, but it says the seller is responsible for maintaining the property in substantially the same or better condition as it was when the agreement was fully executed. So while it's certainly not the seller's fault if a hurricane comes along and damages the property, it is also not the buyer's fault, and buyers shouldn't necessarily be held responsible for that. And so if a natural disaster occurs, I think the buyer can point to this and say, the property is not in substantially the same condition as it was when I executed this agreement, and therefore, I'm not willing to proceed. So, we either are going to negotiate an alternative, and look, if it's give me 60 days because I'm getting insurance money and I'm going to fix it, or this property is destroyed and we're terminating, or something in between, you can always negotiate and change the terms of the agreement, but you're going to need both sides to sit down and agree to that. Otherwise, you're likely to see the buyer be able to say, I'm not moving forward with closing because of that provision and the property is not in the same condition.
I think that clause is really meant to bring everyone back to the table. that point, so that there could hopefully be some work out there.
Yeah, and I know someone raised a question about assignment of insurance proceeds at one point, and in our experience, number one, if you have a mortgage on the property that's subject to this purchase agreement, the mortgage holder is going to have the first rights to those insurance proceeds most of the time. And so, as most folks know, the insurance money kind of runs through the mortgage holder and then down to the owner to make the repairs to get the property back to its original condition. So that would be an impediment to the ability for a seller to sort of assign insurance proceeds to a buyer if there was a mortgage. If there wasn't a mortgage in place, then there's probably a prohibition in the insurance contract that would allow for the seller really to assign its rights in those insurance proceeds. It would potentially be some sort of arrangement where, hey, look, when we get the money, we'll send it to you. But I don't know how many people are comfortable with the idea that the seller is still going to get the insurance money, but then have a responsibility after they get it to turn it over. Even if you had a written agreement to that effect, there's some holes in the ability to sort of enforce that and make sure that the money gets in your hands as a buyer. So in most cases, what you would probably say is, let's delay closing. When you get the insurance money, you fix the property, I'll come back and re-inspect, and then we'll move forward. And that's probably the most likely outcome in that situation. So next slide. This deals with the obtain and maintain flood insurance requirements. I know that this is an issue that's been discussed and addressed by the association a number of times. There's at least 3 articles on the website that deal with this, and I've basically taken the information from those articles and tried to boil it down and make sure that it's a good summary of what the issue is. But for those that know or don't, if the property in question, that's subject to a buy-sell agreement, has been impacted by some sort of damage and has gotten some sort of emergency relief, right, and it's located in a special flood hazard area, then you've got the requirement as a seller to notify the buyer that you have obtained in the past some sort of assistance, and that the buyer is responsible for maintaining flood insurance for that property going forward. And so this creates an issue, because if a buyer fails to do this, there is liability on the buyer for failing to notify the seller of their responsibility to obtain and maintain insurance. So we can go through all of it, but I think the slides kind of pretty well lay it out. There are some FEMA policies on this. I think you guys are, and you can go to the next slide, pretty well know the special flood hazard area designations, but there they are in case you need it. That's the definition of special flood hazard area. So you'll typically see that disclosure and know if the property is in a special flood hazard area. The next slide shows you what are the potential amounts. So these deal with the different types of assistance. And so the issue with this is that if the seller does not notify the buyer, and the buyer then subsequently has damage to their home and goes out and gets federal assistance, whether through one of these programs or all of them, and the federal government finds out that, hey, you should have had flood insurance and you didn't, then the seller can be on the hook for this amount. So that's the liability from the seller's perspective for not making that disclosure. And there are addendums, or addenda, I should say, to the purchase agreement that are available on the Realtors Association website. There's 2 different addendums that you can use. One is used in the event that you were the one that received the funds typically, and how much funds were received in assistance, and that way you can disclose, this is how much money we received in assistance to repair our house from a prior flood or prior natural disaster. The other form, the other addendum, is done or used in the instance where you bought the property, the prior person maybe had some federal assistance, but you didn't, and you're not sure exactly how much money was received. And so you can use that addendum to disclose what you know, but if you don't know all the facts, you don't know all the facts. And on the prior slide, you'll see where you can go to get some information on homeowners that may have received assistance and how much, but it is like a Freedom of Information Act request. It is not just, hey, I'm gonna go and I'm gonna get the the chart showing every property owner in the state of Louisiana and every piece of assistance they've ever received. So it's not some simple process. You got to submit a form requesting this information, and then the timeline for getting that information back is spotty at best, and it's not going to happen fast. So if you're a good due diligent buyer, you may want to go out and get that stuff, or seller. But typically speaking, the process is such that it's just not conducive to a normal, residential real estate closing. Let's see if there's anything else. I think that's it, man. I think that's the end.
I have one thing I want to, it's not in the slides, but in 2020, and this was sort of in response to all the relief that was coming from the federal government, from the state, as far as grants and loans, the Louisiana legislature passed an act. It codified at RS 20:34, and it basically provides that the money received by any person, and that includes individuals, it includes companies, partnerships, LLCs, and whatnot. If you receive payment from a grant or a loan from the U.S. government, from any federal agency or any sort of state agency, that money, if it's in the right type of account, is exempt from seizure. So I'm sure we're going to see a lot of that money flowing into your area, hopefully soon. And to the extent that any clients want to take advantage of this, you need to be aware of it. There's some requirements as to how the account gets opened up. The money needs to be segregated. It can't be sort of dumped into the general account. It's actually got to be opened up with almost a lot of folks are using the citation to the act and saying, I want to open a John Doe 20:34 account. And they're putting the money in there. As long as the money is used for that purpose, it's exempt from seizure. Now, if you got a loan from the SBA is going to have a lien, and that's permitted. And it's not going to exempt you from seizure from child support or alimony. But from other creditors, it will be exempt as long as you're using it, you're segregating it, and you're using it for that the purpose for which it was given, which is going to be disaster recovery, rebuilding, and so on. So keep that in mind. That's something I'd forgotten about and was reminded recently. Again, it was in response to COVID, but it applies to any natural disaster as well as any emergency declared by the government. With that, we can start taking some questions, and I guess Amy can read off.
Can you cover what a broker should do with the security deposit of a sale where there's a dispute on whether the sale will go through or not? So what would the broker, or what should the broker do with that deposit?
Yeah, so, until such time as you get an order, either an agreement of the parties on how to disperse the deposit, right? First of all, that would be the most advantageous situation, is that buyer and seller sit down and agree how to address the deposit. But if the closing's in limbo, so to speak, and you're sitting on a deposit and don't know what to do with it, you can do nothing until you get either agreement of the parties or an order from a court. Alternatively, a broker can deposit that money into the registry of the court and say, there's a dispute here and I want out, and I'm putting the funds into the registry of the court and backing out, and let them fight about who should get the deposit and so forth. That would be atypical unless there's already pending litigation. And then if there is pending litigation, then the broker sort of could appear in that capacity solely to deposit the funds in the registry of the court. And they just sit there until the judge decides who gets the money. I'm trying to think of other.
Yeah, that may, Eric's, it's called a concursus proceeding. It may not be practical for small amounts of money. Right. So I think the broker's probably best course is to continue to sit on it until they're instructed otherwise. And if one party or the other wants to really sort of force that through, they're going to get a court order, okay? Or they're going to come to some sort of joint instruction that the agent the broker can rely on. But typically, it's joint instruction or an order of the court is the only time I need to act, but I can use that concursus proceeding deposited in the registry of the court.
Yeah, and if you have a written agreement that dictates what to do with deposits certainly look there first. So I know some probably do and some may not, but you should have probably a written agreement that in your role as sort of escrow agent of holding the deposit, what are your responsibilities, what are your duties, what are your obligations with respect to the deposit, and if you have a written agreement that spells that out, look to that first and see. But typically, what those agreements say is, if there's a dispute, I get to wipe my hands of this, put the deposit with the court, and move on with my life.
What do you do if the court's closed?
Wait.
That's a good question.
Yeah.
So if the court's closed, it's closed. If it's not closed, but there's a suspension going on, like I said, you can still initiate the proceeding. But yeah, I mean, if you're stuck in limbo to that effect, where a court is closed and not even taking filings, then I think you've just got to let the money sit in your account and notify everybody that you're not dispersing it until you receive notification, signed, written directions from both buyer and seller, or a court order issuing, directing you how to disperse the funds.
The good thing about it is I think we're past that no access to the courts now for the most part as of last week and this week. There's sometimes that are limited, but there's e-filings that I think most of them, at least Terrebonne Parish has, that can be done online and everything else. So there is a way to get through there. Again, going back to the force majeure lesson, if it's burdensome, too bad. It's got to be impossible for you to not take advantage of that if that's what you want to do.
So at one point earlier in the presentation, you were discussing a portion in the agreement that's designed to get the parties back to the table. And in some instances, you may not have the willingness to do it. But in this particular instance, there was a closing scheduled for the 30th of August, and it didn't happen because of the storm. The property did end up having damage, and the buyer wanted to work with the seller and get assigned the insurance proceeds or extend the closing and let the seller make the repairs. The seller decided not to sell at all, and then they terminated the deal. So the buyer is wondering if there's anything they can do regarding the $4,000 in incurred inspections, appraisals, all those costs associated with that due diligence project, and any guidance for the buyer if there's any. And then as a follow-up to that, what's the best practice, or what can you recommend to try to get the parties to the table in having those discussions and renegotiating terms of the contract that had been agreed upon?
Yeah, so on the first part, and we kind of touched on, the ability to assign insurance proceeds and or wait. And so in that instance, it sounds like the buyer was willing to accommodate the seller and give them some options to continue with the closing and still move forward. And so impossibility of performance really wasn't there. It was just an alteration of performance. I think if the buyer has made reasonable requests for accommodations, they've certainly got a claim for the damages that occurred as a result of the seller's failure to sort of agree to those, because the buyer was ready, willing, and able to close subject to some conditions. Now, of course, counter argument from the seller side is going to be, look, everything changed when the hurricane hit. The property was in this condition at the time we signed, and then the hurricane hit, it was damaged. Circumstances changed, and due to the fortuitous event as defined in the civil code, I shouldn't be held to the performance of that contract any longer. I think that one would, typical lawyer answer, it depends on the facts and the parties and all that good stuff. But I think there's, probably good arguments of both sides in that case. But if the sole request from the buyer is, I just want to recoup what I had incurred in this thing, I think that's a better argument than specific performance and requiring the seller to sell on the terms that the buyer requested, because specific performance, number one, is difficult to obtain in any case. And number two, you're trying to demand specific performance other than in exact terms of the contract, right? You're trying to say, I want you to sell it to me, but I also want you to repair it first, or I want you to give me all the insurance money. So you've changed the terms of the deal. So I don't know that you can give specific performance in that instance. But I mean, I think there's a possibility that you're successful in saying, I incurred these costs in the process of due diligence, and I should be reimbursed for those because I tried to close and the seller refused. I don't know how far that goes, because I think a lot of courts are going to have a lot of sympathy for the defendant in that case, where, look, I was ready and willing and able to go until this hurricane hit, and that changed my life, and that changed everything, as you know. And there's just always going to be the human factor in every situation, and whether or not a judge is really looking to hammer a person whose house just got damaged by a hurricane and make them pay $4,000.
And then and there's a practical argument about Eric and I are not litigators, you probably can tell. So we don't favor that sort of avenue. That's why we favor a very detailed and precise contract on the front end of it to avoid that. But if you're stuck in that situation, you have to kind of look at it practically. I always make the joke that anybody can sue over anything. I could sue a ham sandwich because I think it tastes like bologna, but that doesn't mean I'm going to be successful. And what am I going to get in the end? So it is a cost benefit analysis there about there's no sort of shortcut to getting a contractual answer other than maybe sue it in court or some sort of arbitration if that's provided for. But again, even that is not without cost and risk.
Yeah.
So
and to get the seller to come to the table and renegotiate, it's unfortunate, but I mean, it's almost like the buyer has to have a legitimate sort of, I don't say threat, but legitimate threat of successful litigation or right in litigation to say, look, I'm going to come after you if we can't sit down and agree to this. And the buyer may or may not be bluffing, but that's often the way to get people to the table, is if they think there's some risk that if they don't come to the table and agree on a resolution, that they're going to be worse off. And that, again, like Troy said, we're not litigators, and we don't like to see our clients litigate anything if they can avoid it. We like for people to sort of sit down and be reasonable about it. But if somebody says, nope, I'm done, I'm walking away, it's very difficult to make anybody do anything unless you can go out and you really enforce your rights. And that's done, through litigation for the most part.
Flood, obtain and maintain. You mentioned being able to maybe see if some funds were, given to any party. Where would you go to?
Yeah, so there's a slide in here. So you can go to.
Is this it?
Yes, that's it right there. That's the slide. So as I said, one is the state, the Division of Administration is the last one. And that has to do with community disaster block grant, disaster recovery. And so you can go through there and say, okay, I want a Freedom of Information Act request with respect to any and all funds that have been paid with respect to this property. And you can list, the address or the current owner, right? And then I would do both. I would say assistance given to these people who are the current owners and with respect to this property, because it might have been prior to their ownership. And you would submit that same request through it's called Freedom of Information Act request through FEMA, and then through the state's Office of Homeland Security and Emergency Preparedness. So those are sort of the three places where the records of the funds being paid out would have been kept and maintained. And if you make the request, they will provide you a response and let you know if funds have been sent there. But at the same time, I mean, I know these FEMA FOIA requests are probably 6 to 8 weeks out in terms of response time, and maybe more than that. So, you don't typically have 6 to 8 weeks to close a purchase. So it's kind of I don't want to say hollow right, but it's difficult because of the timing issues.
Any other questions? What do y'all have? Both Troy and Eric are great resources. They're giving practical advice on, what you can do on the front end. It sounds like we probably need to do a follow-up on contract writing.
Yeah, and
Maybe so.
The standard form contracts being rewritten as we speak, and there will be a new standard form, and Kim at some point can fill you in on more on the details. And obviously when the form comes out, we'll be able to educate people on the changes. But as I appreciate it, there is in this new form still not a casualty provision. I know that there was some discussion about an addendum that would cover a casualty like a hurricane. And it seems to me that, every year we have a major storm hit Louisiana. And so these issues pop up every year. And yet, the contract doesn't really address it. So I can only imagine that at some point there's going to need to be some addition or addendum that you can use to address this issue. Like, for instance, if you're in a parish below I-10, you've got a much greater chance of this kind of storm hitting and causing this problem than above I-10. So maybe it's an addendum as opposed to part of the contract, but it seems to me like it's got to get addressed at some point. But that doesn't mean, you can't add a provision to it if you're an enterprising buyer or seller, or you're representing a buyer or seller and you want to put together your own addendum that covers what happens in the event of casualty. What we typically do in our commercial real estate transactions is have a provision that says, look, if there's a casualty occurs and it looks like it's going to be more than 60 days or more than 90 days to repair it, then it's sort of a substantial repair. Then either side has the ability to walk at that point, or alternatively, you have a provision that says, the buyer will undertake the obligation to repair and restore the premises back to its original condition using insurance proceeds. And then at that point, the seller will buy. And so,
and usually a delay in closing because of that.
Yeah. And you just say, we're gonna put off the closing until all of that gets done. But one side or the other could be very interested in pursuing the deal or walking away, depending on how much insurance money is involved. I mean, an owner of a property might say, look, I'm going to take the cash and walk, right? If they don't have a mortgage on it and they don't have any obligation to repair the premises, they might be perfectly happy with the idea that they now have an empty lot for sale and a bunch of cash in their pocket and they're moving to, Hawaii, whatever, right? So it just depends on what side you end up on and whether you want to do the deal. But, we usually address that by sort of saying, if it's capable of being repaired, if there's insurance available, buyer's got to repair and the seller's got to buy, or they can both agree to sort of go their separate ways if it's such a repair that it's not capable of being done in a reasonable timeline. So that's sort of the typical way it's addressed in our commercial real estate transaction.
And the property owner, both in commercial and in residential, still has to deal with their own lender, right? That has a mortgage on the property to make sure I can do all those things. So even in the commercial setting, if there's a mortgage on securing that property, I can commit to make the repairs and do these things in my sale agreement, but I've got to make sure that my lender is going to let me do that, because they may want to walk from the deal. They may want to take their loan proceeds, pay off the loan, give you the residual, and go from there. So there's a lot of moving parts, and there's a lot of legs to that stool that have to be sort of addressed. So one thing, I did one of these conferences live on the North Shore a couple of weeks ago with Kim, and during that there was a panel of realtors who had lived through Katrina and the aftermarket there, and the before market and aftermarket there. So I don't know the profile of the folks that are listening and everything else, if they're sort of new to the industry, new to the area, first major hurricane they're dealing with and everything else. But I think one thing I came away from that was if I was in that situation, I would certainly reach out to people that I know had gone through it to sort of hear what the street talk is, what's going to be the issues that I'm not thinking about, what I don't know now, which is the most dangerous and everything else. So I would sort of reach out to people that may have gone through that experience before, whether it's in your area or some other area in New Orleans or otherwise, and get that industry experience, reassurance, because you all dealing with people who are handling it's a very emotional situation for them, personal residences, whether they're buying it or trying to sell it. And there are ripple effects that happen down the road, right? Every sale of a home means there's going to be a purchase somewhere else from the former owner or something like that. So these events sort of have that ripple effect, and the groundswell can sort of build and everything else. So get as much advice you can from the people who who've lived through it, and I think you'll benefit from that. So.
I see a question in the chat regarding composing addendas, addendum. Yeah, I mean, I think the question is, isn't it risky for a realtor to provide it? And yeah, you should consult legal counsel, have them help you draft that addendum so that it is, consistent with the agreement. It obviously, it needs to sort of go hand in glove with the agreement and not be contrary completely. So I think if you put one together, it's taking a concerted and organized effort to put together one that sort of works and is scalable and usable throughout, and not try to create a new one every time that you do a deal and try to draft on the fly and all that kind of stuff. So, and I think Kim responded about, property damage addendums after the storm, that the association has provided some of those that are available to be used. So there are addenda available that the association has put together. And that's always, sort of the preferred step is, as a group, let's come up with what we think is an addendum that works, as opposed to everybody sort of coming up with their own methodology, because then you get consistency, you get a greater, pool of minds to come together and figure out what is the right solution, and all the benefits that come along with that sort of uniformity. And that's why we have a standard form purchase agreement to begin with.
Other questions that somebody has regarding the topic that has been covered, regarding transactions post-disaster. We will make this available, the recording available, as well as their presentation materials. We'll add it to that transaction guidance website. And then also, you always have the ability to, as a broker, submit a legal hotline question. Now, these questions are not transaction specific, but if you're looking for guidance in a certain area, you can submit those legal hotline questions, and we can supply kind of best practices or an answer back to you as it relates to that.
Yeah, Amy, that's a good point. In the hotline request, sometimes specific answers are sort of wanted for a particular situation. And from a legal standpoint, it's very difficult to do without having a lot more facts than you can sort of fit into the request, right? I think the best we do, and maybe even the best LR can do in a lot of situations, is point you to the process, point you to what sort of the rules are, and then let you sort of apply the facts. And if you need further help, then you're gonna have to seek legal counsel to sort of help you get through that and everything else. But the process will answer a lot of the questions as long as we can identify what that process is in our responses and what LR responds to you. I think you'll be much further along, if not, at a full answer to what you're asking.
Yeah, and there's lots of resources available through the association. And as Troy said, this isn't the first time that people have been through this, whether it was Hurricane Laura last year or any of the other, many, many hurricanes we faced in the past. So, don't think, typically speaking, what you're experiencing is not solo or individual to you, and it's probably been experienced by others or is being experienced by others. And so utilize the resources available within the community to see how other people are addressing these issues, which is what we're doing. But there's take it one step further as necessary to continue to reach out to the association or the other members to see how they're handling the issues that come up.
And it was really good that in your comments earlier, when you were asked a question, the response was, well, it depends. It depends because there's so many different factors that have to go into how you are able to formulate that answer. So I think that's really helpful on that end. And with that, I thank you all for your time this morning. Thank you, Troy. Thank you, Eric, for being here. As those of you who participated, if y'all have questions or areas of topics that you would like to see us look at and look into, certainly let us know. Kim is always a great resource for that. You can send us an email at info@larealtors.org. This recording will be available shortly, probably by midday today on that transaction guidance website. Thank you, everyone. Thank you, Troy. Thank you, Eric.
Welcome. Thanks.
Well, it's our pleasure. Thanks.